My name is Laura Bianchi. I'm a partner with Bianchi and Brandt Law Firm here in Arizona. I've been in this industry since 2010, which is a little bit like dog years, so actually about 77 years if you calculate it all together. Today we are going to be talking about commercial contracts, and I know everyone has had a long day and a half and you can hardly contain your excitement. And while contracts may not sound like the most exciting and sort of sexy part of the marijuana industry, I assure you that over the next 30 minutes or so, we're going to talk through really the purpose of commercial contracts and why they're so important for not only your current success, right, in this initial program, but for really building out your long-term success, which is pretty sexy when you think of it that way. So would love to get started. Just a little overview today. We're going to go through really what makes a contract. What is a contract? What comprises a contract? Then we're going to talk about the importance of contracts from a business perspective. We'll move into talking about contracts and the importance of them in the marijuana industry specifically. And then we'll walk through a couple of the different types of contracts you might regularly see, what those look like, the purpose, the goal, and of course we'll end with what happens if you hear none of this and actually don't put any good contracts into place. So I certainly appreciate your time. We'll get started. So contracts. I know when the subject comes up, most people think, oh, tons of pages, lawyers, small print, lots of legalese in Latin. It's not fun. It really doesn't have to be this difficult. So if you really break down what a commercial contract is, you've got a couple of elements, right? You've got an offer, you've got acceptance, you've got mutual intention, and you've got consideration. What does that mean? I know, big words, doesn't need to be complicated, an offer, right? You come in and promise to pay, you promise to actually mow my lawn, and in exchange you ask for something of value, right? That's an offer. It's a service that I need, and so I accept that offer and say, sure, I would love to have you come and mow my lawn once a week, and I'll pay you something of value in response. The intention part, right? People go, I don't really understand that. The intention is just that both people agree that we want to actually enter into a legally binding agreement, right? We both agree there's an offer, there's acceptance, there's that intention, and the consideration is really just the value that's being paid for that service. So in this case, we could say, keep it simple, I'll pay you $20 a week for you to mow my lawn. We haven't really valued, inflation for landscaping here, but it's really that simple. So, a lot of people go, well, I need lawyers, I need to start. When you sit down and start looking at these important relationships, right? You're going to need employees, CPAs, lawyers. You're going to have to enter into lease agreements. You're going to have to look at security agreements. There's a whole host of things that you're going to come across in the marijuana industry, and every one of them requires a contract. So once we get those four elements down, right, we look at what really is the importance or what's the purpose of a contract from a business perspective. Now, again, we've got those four elements, but there are other types of terms and things that you want to work through and make sure that they're clear in an agreement. How long is the agreement? Is it for a year? Is it for 6 months? Is it for 2 years? What are the main terms, right? What's the compensation? You want to make sure that you're clearly describing the services, right? Are you going to come and mow my lawn once a week? And does that include planting flowers? I don't know, treating weeds, right? Or is it just mowing the lawn? Those are the types of terms and things, and I know I'm simplifying it, but those are the types of things that we go, if we don't have it in a contract, if we're not clear and concise, those are the things that can lead in a much more complex setting to fights, to disputes, right? And that's the last thing we want to do. So from a business perspective, we want to make sure everyone is in agreement, right? We want to have a clear way to break up. Sometimes these agreements don't work. Sometimes personalities don't work. And so you want to make sure that you have a way, if this isn't working for either party, to actually exit without having to go to court. Last thing is you also want to make sure that you've got a way to measure success, right? So a lot of times you're bringing in companies that are performing services for you that maybe aren't your skill set, right? That you're relying on their advice, their expertise. So how do you know that at the end of the day, what the service they're providing is the same level that you want, or that it's actually up to your satisfaction, right? So there's got to be some way to actually tell, are we being successful in this agreement? Do I think there's value in what you're providing? Are you providing that service up to my satisfaction? And then I'm paying you whatever that consideration is. So those are kind of high level, just the bigger ones. Next, of course, we would move to importance of contracts in the marijuana industry, right? And you go, well, how is that different from a business perspective? Well, I don't know how many of you know, but in 1996, that was actually the first time our medical marijuana program was implemented. And that happened, of course, in California, where the voters approved Prop 215. That was only 25 years ago. So if you look at today where we sit, we've got 36 states plus Washington, D.C. that have some sort of medical marijuana program. We've got 18 states plus plus D.C. that have some sort of adult use or recreational program. And we've got another 13 states that have decriminalized marijuana in some fashion. That's an insanely fast growth pace, incredibly fast, right? To just make things a little bit more complicated, each one of those programs is totally different, right? Each one is completely different. None of them are the same. Every single state program is different. And despite the fact that Washington, D.C. has both a recreational program and a medical program, the federal government still sees this as a Schedule I drug. So that means marijuana is right up there with heroin, opioids, cocaine, all the fun ones. So it's another layer of complexity, right? It's uncertainty in this industry. You've got different programs, you've got a really fast growth pace, and you've got the federal illegality that we deal with on a regular basis. Those things add uncertainty to your business, to your operations. So you say, well, okay, how does that actually apply to what we're talking about and to contracts? Well, first of all, anytime there's a dispute or a fight, right, you have different options. Let's talk about it in the traditional sense. You can go through mediation, you can go through arbitration, you can go to court, right? So in a real estate dispute, we have a general idea. We have what we call case precedent, right? That's a way to look back at history and see how law is applied, what happens when a tenant, stops paying their commercial lease, what happens when a landlord wrongfully, evicts a tenant. We have a general idea of what's going to happen, right? So we know with some certainty when we go before that legal proceeding what the outcome is going to be. We don't have that in the marijuana industry, right? Again, only 25 years. So when we look at this, right, and we say, gosh, I don't know if I'm going before a judge that has any idea how the marijuana industry works, or does he know the actual marijuana laws? Do they know how it intersects with our regulatory program? Or does he even like marijuana? That's something you just don't really deal with when I'm going before a legal proceeding on real estate. It's a real world, issue that we deal with in the marijuana industry. So the best way to avoid any of those uncertainties, right, is to stay out of mediation, staying out of arbitration, staying out of the courtroom. And how do we do that with contracts? And I know I keep coming back to this and it seems like I'm beating a dead horse, but again, when you've got clear and concise contracts in place, the overarching goal of not having legal disputes, or if there is a fight, having a clear path forward overcomes that lack of historic knowledge, that lack of case precedent, right? We can go forward, and even if you have to go through a legal proceeding, you actually have a clear path and it will be to your benefit. So while I know a lot of times it seems like we're just trying to sort of create work for ourselves, it really isn't the case. If you've got clear and concise contracts, especially in the marijuana industry, you've given yourself a path forward and you've minimized the chance that you're going to have disputes and fights that have to be adjudicated by an individual that may not have all of the expertise that you'd like them to have, right? That we have available in traditional industries. So, of course, then we look at what are the different types of contracts in the marijuana industry. Now, there are all sorts of things. Many of you, of course, are obviously here because you're interested in the social equity program application process. So you've looked at creating an entity. That could be an LLC, that could be a corporation, right? So the first area or the first type, I guess, of documents is your corporate documents, right? Those could be operating agreements, they could be bylaws. This is the place where the structure and the management of your company needs to be spelled out. So that could be management decisions, voting rights, percentage of ownership, things like what happens if someone wants to leave the company, what happens if someone passes away, what happens when you want to expand, who makes those decisions, right? How do we bring capital into the company and how are those decisions made? How do we handle distribution of profits and debt and all of those different things that come into play in the operation and the structure of your corporate entity. So as you guys go and you start to form these entities, don't bypass the corporate document as, I'll get to it later on. It's an easy thing to do, but that document becomes so important as you move forward because that is what the law considers, your map for how your company is owned, how it's structured, and how it's operated, right? Second area, joint venture agreements and partnership agreements. I can tell you from my 77 years of experience that the most amount of disputes in this industry come from disputes between partners and joint ventures, right? People are so excited in the beginning. It's sort of like dating. Everyone's on their best behavior. We're super excited. I bring the money, you bring this. No one takes the time to sit down and really go through that contract, right? What did we talk about? Offer, acceptance, intention, and consideration. Those four sort of silly elements. But if you don't sit down and go through that, again, as you get your license, as the business starts to evolve, as problems and complications and things start to happen, as disputes start to arise, if you don't have a path forward with your partner, if you haven't established expectations or responsibilities or roles or who's in charge of what, those are the things that can cause these relationships to absolutely explode. And you'll find yourself in a position where you're spending so much time, so much money, so much emotion fighting battles between partnerships that you aren't able to really appropriately focus on the business, on this incredible asset that we hope you all will acquire, right? And this is an expensive industry. I would absolutely be remiss if I didn't say that. So there are very important decisions that you've got to make with your partners. Coming into this to begin with, there's a lot of upfront costs, a lot of big decisions that have to be made, and having that agreement in place and in writing, again, is one of the ways to just limit the chances in the future that you have a fight or you have a dispute that really can detract from your long-term success, right? Remember what I said in the beginning. I know it doesn't sound like the most fun part, but having these contracts and limiting the amount of time and money you spend fighting absolutely helps you build a foundation for long-term success. Right, so next we look at management agreements. So you're going to hear this term quite a bit in the marijuana industry, and there's a host of reasons for doing them. But really, to simplify, especially in Arizona, right, we're a vertically integrated license, and so you're going to have the ability, of course, to have your retail dispensary, and then you can have your off-site cultivation, you can have an off-site manufacturing facility, right? Now you may come into this and say, hey, I am super confident in my ability to run this incredible retail dispensary, but I don't know cultivation as well, or maybe I don't know extraction, or maybe I need assistance with packaging or brand development, or all of these different things that you're going to find become an important component of running a vertically integrated license. And so in those cases, you'll want to bring in others from the outside, others who have experience, who have knowledge, who have done this before, either in Arizona or in other states. And a lot of times those relationships can be formed and they can be structured through management agreements, right? The other thing you want to make sure too is, while it's a great bonus to have these individuals coming in who have expertise, a lot of times people are operating outside of their element. And so remember what I said, even in management agreements, right? What we talked about from a business perspective, having ways to measure success, making sure that you've talked through what does accountability look like? What does the success look like? What are our goals? What are our thresholds, right? Because management companies are going to have a lot of control sort of in the physical sense, especially when you talk about running other types of facilities, cultivation facilities, extraction facilities. Those are all under your license. They're your responsibility. They're your obligation. That sits on your shoulders as the license holder, but they're in possession a lot of times of your facility or of your product, right? And your ability to continue to put your brand out there and to sell on the wholesale or even on the retail, out of your retail dispensary, can lie within the hands of these management companies. And so these are incredible relationships. You can find really great quality people out there and companies and entities that will come in, and you can build something and be successful together. Unfortunately, like any industry, you can also find not so great people who will come in. And a lot of times the license holders won't know that until we're so far down the road, right? And it's a very difficult thing to break because, again, it's under your license, but they're in control of your product or they're in control of your facilities. So management agreements are one of those areas that absolutely, from a contract perspective, make sure that you work through the material terms. I can't say that enough. I can't implore you enough. At the end of the day, it's your license. This is your multi-million-dollar asset in your business that can be incredibly successful and benefit you and the community that you're in and all of the plans that you're thinking through right now as a social equity applicant. But if it's done incorrectly, you can find yourself wasting an incredible amount of time and energy and cost, again, with the wrong agreements and fighting things from a legal perspective, which is just really unfortunate to see and happens, I would say, more often than not. Next thing, of course, we want to talk about is lease agreement. And really, you'll have different types of real estate agreements, but because of the way our system is structured here in Arizona, you've got to get your retail dispensary open first and foremost. And so a lot of people will go and say, great, I want to lease that retail space. And most commercial landlords have a form, right? Commercial lease agreement that they'll give you. It's got the basics in there. It's got all of the things that they normally ask their tenants to agree to and sign. And that's great in a normal situation. But this is one of those that, again, because we are in a highly regulated industry, because you have to have authorizations from the Department of Health Services just to be in these facilities, you've got to sit down and carefully go through those commercial lease agreements. And a lot of times, this is where having the right attorney who really understands the marijuana industry is so essential, so important, because you're having to explain to a landlord that in a normal situation, you come and go in your building as you please, right? It's your building. Not the case when there's marijuana involved, right? These are special authorizations. You've got to make sure that your license and your operation is compliant at all times. That even means from the landlord, right? And sometimes that's a difficult conversation to have because they'll feel like, this is my building. I can do what I want. I can come and go as I like, but it jeopardizes your license, right? And your operation. And so it's really important to sit down and have an idea of, number one, is this a good deal for me? You also will find a lot of individuals out there that understand the importance and how rare it is to find a good location for a dispensary or cultivation or any type of marijuana facility. And so sometimes the terms that are being offered can be outrageous. I understand, and I will be the first one to tell you that in the marijuana industry, you will pay more for your leases. You just will. It's a matter of fact, right? It's the landlord taking on some additional risk. We understand that, but you don't want it to be egregious. And you don't want it to be something that's going to drown you before you've even started, right? So we consider things like ramping up in the rental amounts, right? Or how much does this increase? What are they looking for, right? Again, you want to look at the length of the lease. You want to look at the rights and remedies, not only of you as the tenant, but of the landlord, because another complication to consider is it's not easy to move, right? If your office, floods or we have an issue, finding another office, while it's not fun, is not an impossible feat, right? It's usually something that could be done in a couple of weeks. Not the case with a marijuana facility, right? Again, there's an approval process. You have to move your approval to operate. You have to make sure it complies. You usually have to go, as you just heard, through the zoning and land use process, which can be complex and long. So you want to make sure that your lease agreement, in the event that something happens, you actually have time to go through the process of finding another location and relocating, so that, again, you don't find yourself in a difficult place, because these terms and these types of details are perfectly normal in a commercial lease agreement for any other type of industry, not in marijuana, just because of the complications we have. Of course, right now we're talking about lease agreements. That also applies if we're talking about a purchase and sale agreement for a lease. Getting a title commitment can be challenging. There's just a lot of things that, again, going back to the fact that from a federal perspective, this remains illegal. So you've got the conflict between the two. And so there are a lot of industries, as you'll find, title companies, escrow companies, financial companies, who are very hesitant because of their relationships or their benefits from the federal government to do business in the marijuana realm. And so just complications and hurdles, look, we certainly address them. We get through them. We've come a long way. A very long way in the last 25 years. We still have a long way to go. But those are the types of things that you want to make sure that you're aware of, and that you have someone helping you go through these contracts and agreements and make sure that the terms are beneficial, allow you to operate in a compliant manner, and don't put you in a position that you suddenly find yourself in that's very difficult and can be costly and even put the license at risk, right? And your business at risk. Of course, next would be employment contracts. Now, this is Arizona is an at-will employment state, as many people know. So it really gives employers a lot of power and control to hire and fire. Of course, you can't if there's a constitutional protection, excuse me. But otherwise, you will find a lot of, hourly employees. We don't have employment contracts. However, I think what you'll also find in the marijuana industry is that higher level management executives, individuals to help you handle compliance, to help you handle security, right? To help you handle the management of this entire sort of complex company becomes necessary. And so in those cases, you're usually talking about higher level executives, and you're talking about individuals that you want to come to terms with, right? You don't want them to work for you and then, a year from now go down the street and take all of sort of your proprietary knowledge and things like that. And so in those cases, we want to make sure you have really solid employment agreements. Now, you can have an attorney help you put something together that is sort of comprehensive and across the board for your executive team, but you want to make sure you work through those specific details with each individual, right? What's the length of the contract? How do we break up if it doesn't work? If the personalities don't work? If you're not meeting the thresholds or whatever those success milestones are, right? What are the benefits? Vacation policies, all those things that again are normal, right, from an employment perspective, but can make a big difference in the marijuana industry because of all the rules and regulations and hoops that we have to jump through, right, to bring people into these companies. And so again, employment contracts is just another area where you want to make sure that you've gone through those 4 elements, right? What's the offer? What service are they actually providing you? What are they obligated to do? What are those roles and responsibilities and expectations? Have you accepted it? What is the value that you're paying them, right? There's your compensation and things like that. And is there a mutual intent? As long as you have those things, again, you've got a complete and comprehensive contract. And I know, again, I'm repeating myself, but I'm hoping that helps it sink in, that is one of the best ways to ensure that you don't have, or you at least have limited disputes and fights down the road, because every single one of these battles, again, it costs time and it costs money. And unfortunately, in the cannabis industry, it tends to always cost more in the sense of time and money, just because of the hurdles and complications that we face. So in addition to employment agreements, we have independent contractor agreements. Now, I won't spend a ton of time on these because really a lot of these contracts can also be independent contractor agreements. Your management agreements can be that. A lot of times you'll have vendor agreements, your CPA, sometimes it's your human resources. It could be your company that handles your marketing and PR. There's a lot of different services, really all of the services that you would need in any business, but you also need them in the marijuana industry. And it's just very important that you have everything agreed to in your contracts. The more that you've got those complete and comprehensive contracts, again, the better the chances we stay out of mediation, arbitration, away from judges, all of those things. So we take away at least the areas of uncertainty that we can control. There is enough uncertainty and changes and things in the industry just by virtue of being new and still evolving and still growing. So if we can limit the liability, limit the risk, and be clear and concise. Again, you don't need a 50-page contract that you need a lawyer to actually interpret, right? You want to be clear. You want to be able to read through this and both parties agree and say, yes, I understand what was agreed to, I understand we're all on the same page, and here's what happens as we move forward. So, of course, last but not least, what happens if you leave today and just ignore everything I've said? And some of you will, and that's okay. Of course, as we talked about in the beginning, disputes will happen. This is an industry that is very sought after. There are so many people, if you have not seen it already, who are so incredibly anxious and eager to acquire license. Everyone has been waiting for the social equity program to come into place, right? And so this is such a sought after asset, and there is so much potential for success, not only in Arizona, but then to be able to do things in other states and expand and really grow in this industry. So when you have that kind of attention, when you have that kind of desire, fights start, right? There's a lot of money at stake. There's a lot of big decisions at stake. There's a lot of things that will spur disputes, and as I said, a lot of them are usually between partners, things like that, but it also can be between management companies, things like that. And so when you don't have the right contracts in place, when you don't take the time initially, that's when disputes happen. And I've seen people waste so much time and so much money, again, going through mediation, going through arbitration. I was a part of an arbitration that lasted almost 6 years. That's insane, absolutely insane. And why? It's just the virtue of this industry, and there's so much additional education, and there's so much additional work that we have to do really as lawyers or as experts in this industry to make sure that the individuals who are making decisions regarding these disputes and regarding these fights and these battles, that they really understand the marijuana industry and they understand the laws and how it works with the rules and regulations. And so when you add that component in and you take out the historical precedent, or you take out the ability to have a lawyer or a judge who really has extensive experience in this area, it complicates things. And it's, this is an exciting industry and there's a ton of opportunity. But as I said, for real long-term success, the individuals who do it right and take it step by step, they don't fly through things, they don't skip the steps, they don't fail to do due diligence, they don't fail to actually put the right contracts in place, they don't fail to get the right professionals to help and advise them. Those are the individuals that make those incremental leaps forward. And that's why I say that while contracts may not be as super exciting as some of these other areas that we talk about, it absolutely can create that solid foundation that will allow you to be successful in the long run. And it allows you to not waste as much time or waste as much money or as emotion and things like that. So it is essential in the marijuana industry. I cannot tell you that you pave your own path going forward, that you don't rely on sort of that lack of history. And it's growing. We're getting our case precedent, but it's still a work in progress. And so if you really pave your path forward and have very clear direction in your contracts and agreements as to what happens when each of these things in life occurs, it just puts you in a much better place.